Thank you, everybody, for joining us this afternoon. We know that there are very interesting panels going on at the same time. So being here, it's already showing a special type of interest about civil liability and ADMS. So I think you are in the perfect place because we have an amazing combination today of practitioner and academic experience around the table and joining us through Zoom. And to kind of introduce the panel and introduce everybody, what I'm going to do is just quickly give it 2 minutes to each of our panelists to briefly introduce themselves and what they're going to be talking about so we can have an idea. And first is going to be Henry Fraser, who is a young legal scholar who actually left the chromatistic idea of a career in corporate legal to join academia. So probably he gives the right balance, but from the more idealistic perspective. So, Henry.
Thanks so much, Jose Miguel. I developed an interest in civil liability just because in the conversations that I was having as I came into this area of AI accountability, it struck me that there's room for kind of rigorous legal analysis of how to extend existing principles, which is not to say that's the only thing that needs to be done, not by any means, but in terms of where there is rich veins of first principles about ideas of responsibility, especially where there are attenuated kind of relationships, negligence struck me as a good place to start, and also to so I kind of was attracted to negligence. And it has that appeal of flexibility too. So I've done a bit of work looking at conceptually what negligence can tell us, and then also thinking about how to overcome some of the challenges, and that's what I'm going to be talking about today.
Thank you very much, Henry. Associate Professor Henrique Sousa Antunes is joining us from Portugal. Thank you very much for the early start. And he was the dean, if not one of the leading law schools in Portugal, the Católica in Lisbon. And he wrote actually the seminal paper on civil liability in the EU context for artificial intelligence. So welcome, bon dia.
Bon dia. Thank you very much for your kind words, Jose Miguel. And good morning to you all, or good afternoon. It depends, of course. It's a pity that I cannot be with you together, but okay, that's fine. It's a very viable solution so that we can gather here. Well, very briefly, when I started teaching my academic career about 30 years ago, I was assigned the Law of Obligations course. And of course, then I developed a very special interest on civil liability. And it came naturally when artificial intelligence began to be on the table to study the topic of civil liability related to artificial intelligence. And as you probably know, the topic is quite a hot issue right now in Europe, and the discussion is taking place. We are still waiting for the position of the European Commission on it. So, I mean, this is the reason why I've been writing on the subject, and the reason for having the honor, and I take the chance to thank Dr. Henry Fraser for the honor of the invitation. So this is basically what I have to say within these 2 first minutes. Thank you, Jose Miguel. It's a pleasure to be with you again.
Thank you. Seeing you again is always a pleasure. And coming back to the room, I have Natalie here on my right. She's a social legal scholar and a practicing lawyer. So we're giving the right balance between both sides. She has very insightful expertise in the domain of discrimination and public interest class litigations. So again, another perfect person for this panel. Thank you.
Thank you. And thank you everyone for attending. I guess this topic for me is really where my professional work as a litigation lawyer, public interest litigation lawyer, meets my research work, looking at the regulation of algorithmic discrimination, particularly around algorithmic hiring systems. A central question for me in that work has been how do existing laws provide protection against algorithmic harms? And that's what I'll be talking to you about today.
Excellent, brilliant. And finally, thank you very much, John Morgan, for joining us, who is an adjunct associate professor at the University of New South Wales. After a long career in legal practice, which I think he sustains as a consultant at Allens nowadays. Good afternoon. Thank you for joining us.
Thank you very much. Quickly to introduce myself, I'm going to say I got involved in motor accident injury schemes and workers' comp schemes and the regulation and structuring of those schemes back in the 1980s. And that really has led through to my current interest in autonomous vehicles and in particularly AI, largely because of the issues that those, particularly the motor accident injury schemes, have to deal with in terms of vehicles where there's no driver. And that leads in turn into thinking about how does the law of negligence work, how does product liability work. So we've had a shift from looking at liability issues by reference to a person, the driver of a vehicle, through to a product liability perspective, and that's the challenge. I think also in more recent times too, that I've been thinking about, as I learn more about AI, and I think one of the challenges for lawyers is to actually understand what the IT people and the scientists are really talking about, to start asking some other very interesting questions, such as, because my other interest in corporate governance, such as the example of a director of a company, what liability may that person have in circumstances where a company, for example, adopts the utilization of algorithmic management systems and the like, or utilizes such systems for producing advice to third parties, for example, in the financial sector. How do we know how those systems really work? How do we deal with the liability issues that arise out of those systems getting it wrong? And how do you know when they do get it wrong? So that's my general area of interest. But today I'll be focusing more on the motor vehicle issue.
Thank you very much. So I'll give the floor to Henry, who is going to start his presentation now. And we'll go for 15 minutes roughly for each presenter, probably a bit less, and then we'll have some time for question and answer. Henry?
Hello, I am going to be speaking on behalf of my brilliant co-authors of a paper which I presented at FACT in Korea last month, but I wanted to present here and reach the Australian audience. It's about explainable AI in lawsuits. So it had to happen eventually. Last year in Texas, police officers sued Tesla in negligence and product liability after they were injured by a Tesla that was on autopilot mode during a traffic stop. And this is not going to be the last lawsuit for an AI accident. Civil litigation is one piece of the accountability puzzle for AI. And as with other forms of accountability, AI opacity poses a challenge. And so the paper explores and evaluates strategies for dealing with that challenge. And we have a sort of general broad focus on areas of intersection between Australian, English, and US law, particularly relating to negligence and also product liability. So we start with this list of different kinds of AI opacity, which is compiled from work initially by Jenna Burrell and then later by Selbst and Barocas. And I won't read out each item on the slide. And we'll get into more detail in a minute about what each type of opacity means by seeing how they all cropped up in the recent Australian case of ACCC and Trivago, which was a consumer law case. So I'll explain how the court managed to deal with opacity fairly successfully and then work outwards to explore other strategies for dealing with opacity in other types of suits. And especially I'm going to focus in this talk on negligence. But first, one of the main things that I want to get across is that the kind of explanation required in the context of litigation is distinctive. As Wachter, Mittelstadt, and Russell point out, the scope and content of explanations should be driven by the goal or action that they're intended to support. And in litigation, the goal isn't necessarily a general explanation of an AI system or even an explanation of the basis for a decision. The goal is to provide evidence to the court that something about the system or its development or its use is unlawful. So explanations need to prioritize the cause of action. And for the non-lawyers, I don't know if there are any here, that's essentially the list of things that you need to convince the judge or sometimes the jury of in order to win the particular type of case that you've brought. So the Trivago case illustrates this clearly. The main cause of action there was misleading and deceptive conduct. Australia's Consumer Affairs regulator, the ACCC, claimed that Trivago, a travel website, misled consumers about hotel room pricing. And at the centre of the case was Trivago's top position offer, which was essentially an algorithmically generated deal, which was presented as the cheapest available offer for hotel rooms. So the court needed to know whether that offer really was the cheapest available or whether there was some other reason it was being ranked top of the list. So both parties needed to explain how the ranking algorithm worked. There are some key takeaways from the case. First of all, there's a big bugbear when we talk about AI accountability. People talk about AI opacity, and we have in the room Frank Pasquale, who's done so much to bring that problem to light. But the case shows that to a certain extent, and in some contexts, the courts can deal with this problem, aspects of this problem. So the first aspect we have is trade secrets or intentional secrecy, people not wanting to give access to an algorithm to proprietary content. And the way that courts generally deal with this is through disclosure regimes, discovery regimes. And at least in Australia, I think in the States, it's less sensible. Like if you want to access software, the limitations are much stronger. But in this case, it was a fairly balanced approach between confidentiality and access. And we'll get into that in a little more detail in a second. The second challenge is to make sure that the judge and the litigants can understand the technical aspects of the algorithm. And Trivago is a masterclass in using expert witnesses to explain technical subject matter. The real coup was getting the experts from both sides to write a joint report setting out the points of agreement and disagreement. And lawyers have a very creepy name for this. It's called hot tubbing. So a third challenge, XAI methods, explainable AI methods, can't produce complete or perfectly reliable explanations or representations of AI systems. And that speaks to the inherent inscrutability of complex systems. I mean, the Trivago algorithm was relatively simple, but there was still disagreement between the experts about how reliable their methods were. But the thing is, courts are used to reconstructing facts from incomplete, conflicting accounts. It's what they do. And parsimony is very helpful here. Courts at least say that they only make determinations about what they need to determine. So in this case, the judge in Trivago didn't need a comprehensive, flawless explanation of everything about how this algorithm worked. It was enough that, in spite of disagreements, both experts converged on the point that the top position offer was often not the cheapest offer, and surprisingly, or rather unsurprisingly, commissions paid were a highly important feature in the selection of the top position. And that's the critical issue in the misleading and deceptive conduct suit. But perhaps the most significant takeaway from the suit is that, from a technical perspective anyway, is that the choice of explainable AI methodology, and therefore the type of evidence that you can provide, is going to be shaped by the level of access and the kind of access to the algorithm and its underlying documentation. And the experts in this case used different methods because they had different levels of access. The ACCC expert used a gradient boosting model, which is essentially a compilation of decision trees, to reverse engineer the algorithm because he didn't receive the actual weights used in the algorithm, and I don't think at one point he even had the data. He was actually querying it. So he had log data, and he combined that with query data. The Trivago expert had full access to the system, and so essentially just explained it as he saw it. Didn't need a surrogate model. But the success that the ACCC had in Trivago shows that it is possible to provide explanations of AI systems that are salient and effective, even if you have less than total access. And one of the contributions of the paper is to try and start categorizing and describing the different kinds and degrees of access and what kinds of explanations they might permit. So the paper proposes 3 levels of access to AI systems. The first is debugging access, which is like an all-access pass, which would essentially put the plaintiff or whoever's inspecting the system in the same position as the developer. So that could take the form, for example, of restricted VPN access to a development environment or a Docker image with the system's libraries and dependencies all installed. At the other end of the spectrum, you have descriptive access, which essentially is what you get if you only get documentation, or maybe even just the code, but without weights or checkpoint file or relevant data to inform what you make of that algorithm. In that case, you can only make general inferences about the model because you don't have the specific model instance that was used in the particular instance that led to the suit. So the middle ground between these two is query access, and that's essentially being able to submit inputs and observe the outputs, for example, through an API. And it struck us that this is really a sensible approach as a kind of a norm of access for inspection, both in litigation and elsewhere, that if there are serious confidentiality concerns, this is a way to kind of balance those concerns with a meaningful kind of access that allows you to interrogate the system to a considerable degree. So now that we're armed with these different levels of access, let's look at some of the legal strategies for dealing with opacity in civil litigation. One is to sidestep the opacity altogether, and that means bringing a claim that doesn't require inspection of the system. So in the Tesla suit that I mentioned at the beginning, some of the claims, at least, not all, but some focus on failure to warn of or remediate a known risk, because this type of accident had already happened several times before. And I think that kind of suit is likely to become quite a common opacity hack, and it already is in sort of technical cases. But it doesn't work if you have a one-off accident, or you don't want to wait for sort of 12 instances of the same accident. In other cases, plaintiffs might be able to persuade judges to draw broad inferences from limited information, or even to treat opacity itself as indicative of fault. And the Australian Human Rights Commission was suggesting about drawing adverse inferences from opacity as a powerful tool. But these approaches do rely heavily on courts making fairly large leaps of reasoning and being very sympathetic. Trivago is a different kind of strategy that was used. It did involve inspecting the system, but it kept the inquiry fairly narrow. The ACCC tends to focus on misleading and deceptive conduct, and in this case did, rather than on some inherent fault in the algorithm, because it distills the inquiry into a Boolean question, true or false, does the algorithm work as advertised? But for some kinds of wrongs or harms, even this type of approach won't be feasible, and that's the case for negligence. Negligence, as I mentioned, is a sort of a quintessential, flexible, fallback lawsuit for accidents, and it has its limitations, but also some strengths. In the paper, we deal with product liability, but I'm going to stick to negligence here, just to keep things within time. So let's imagine, as happened in the Tesla case in Texas, a self-driving car plows into a stationary police car with the lights flashing on a highway at night, and someone's injured. How might that injured person put together a negligence claim against the developer of the car's object detection system? So a negligence claim involves a multi-stage inquiry where you work out whether there's a duty of care, a duty to take care, whether that duty was breached through a failure to take reasonable precautions, and whether the failure is what caused the accident. And the slide here shows some of the subcomponents of those limbs. And the role for XAI in this kind of suit is going to be to prove the causal connection between the failure of precaution and the accident. And doing what the experts in Trivago did, explaining model feature importance, just doesn't get you there. It doesn't tell you whether the accident could have been avoided with appropriate precautions. So you need a different type of approach. So this is the fun part and somewhat speculative. To satisfy the causation test in negligence, the plaintiff has to show on the balance of probabilities that the accident wouldn't have happened but for the failure to take care on the part of the defendant. And the but-for test invites counterfactual thinking. Would the accident have happened if the developer had done A instead of B? The balance of probabilities standard of proof opens the door to empirical, statistical, probabilistic kinds of reasoning. It means that you have to show that some failure of precaution was more likely than not to have caused an accident. If you take that standard seriously, as one eminent negligence scholar pointed out in the 80s, what you're really saying is that the failure of precaution more than doubled the probability of the accident. And this is something that's starting to get into something you can test. And courts don't tend to engage in this kind of statistical reasoning because it's hard, it's expensive, and they don't want litigants to feel that they're obliged to do it. But that doesn't mean they won't accept that kind of evidence if it's before them. So in the paper, we propose this slightly far-out approach to how you might go about satisfying the test, and the flowchart here sets it out. So if you can show that some cost-effective precaution somewhere along the way would have more than halved the frequency of whatever error it was that caused the accident, and you can show that the developer didn't take that precaution, it's not the last word, but it is compelling evidence of negligence. And in principle, with debugging access or perhaps even query access, it's possible to do this. And the paper goes into more detail about the various technical ways you do it. But the headline is, you can work out empirically that an AI system has a certain error rate given inputs that are similar to those that happened at the time of the accident. So say a rate of errors in detecting objects at night with flashing lights present on highways with stationary vehicles. And in fact, the American Automobile Association recently did something similar, testing driver assist systems responses to head-on collision scenarios. So if you have sufficient access to construct a surrogate model, you could show counterfactually that some reasonably cost-effective change or precaution would more than halve the error rate, and that's step 3 in the diagram. So if you show these things, I'm not by any means saying that it's easy, but if you can show these things, what you're showing is it's more likely than not that the accident-causing error is attributable to the failure of precaution, because more than half the errors of that kind are attributable to the failure. So in other words, you're showing on the balance of probabilities the accident wouldn't have happened but for the failure of precaution. Now, to be clear, we're not suggesting that all civil liability suits will or should boil down to this kind of fairly elaborate formula or strategy, or that it's going to be cost effective. But the point is rather to try and illustrate that there are ways to apply creative legal and technical thinking to make inroads on this problem of AI opacity in this particular context. Naturally, the approaches that we've set out all have their limitations and challenges. And broadly speaking, the more complex the use of AI, the more difficult and expensive it will be to pull off, which means the more difficult it will be to access for victims of accidents. And that's certainly true of the counterfactual approach that we've put forward here. The more straightforward ways of dealing with AI opacity are cheaper, but they have the disadvantage of relying more heavily on broad inferences. And there's also the old saw about AI unpredictability and the impossibility of foreseeing and preventing all harms. Even if you can show that some precaution was feasible and would have substantially reduced one risk, you'll end up in a fight about whether mandating that particular precaution would be tantamount to mandating comparable precautions for all the vast array of other similarly serious but equally unpredictable risks. So which measures are reasonable, which measures aren't? But in some sense, that's the question that you want the courts to answer, even if it's only to prompt corrective standard setting by regulators and legislators. And courts can only develop the law to set the standard of care for AI if there are cases before them. And what we're offering are some suggestions about how the kind of thinking that's needed in order to make that happen in the face of AI opacity, making the most of the tools that we have. And what I've got here is just a list of some of the priorities that might give civil lawsuits a better chance of working as accountability mechanisms for AI. Thanks very much.
We'll move quickly to Enrique to stay on time. Thank you, Henry, for doing a great job about that. The floor is Enrique.
Okay, thank you very much, Jose Miguel. Can you see my screen? I'm sharing the screen now. Are you able to see it? Yes.
Yes.
I think so. So let me just, sorry, not, sorry. Okay. Well, again, thank you so much for the honor of the invitation. What I intend to present here today is the scenario in Europe regarding civil liability applicable to artificial intelligence, and also to do critical approach to the proposal that is on the table. So right now, if we want to think about a proposal on this topic, what we have is the European Parliament resolution of 2020. Probably you are aware that in Europe, the European Commission has presented a proposal for regulating artificial intelligence, but civil liability was left out, which is quite, I would say, strange, because if we think about the Data Protection Act, there you have a regulation where civil liability was considered, and so it was regulated not in a separate act, but within the regulation for protecting data. Well, but that does not seem to be the case regarding artificial intelligence, and of course that will probably create some problems in harmonizing these two different statutes. But very briefly, what I wanted to tell you is the following. So this resolution of the European Parliament of 2020 has highlighted the importance of defining a clear and harmonized civil liability regime in Europe for the development of artificial intelligence technologies and the products and services that benefit from them. As I said, it contains a proposal. And the proposal, when one reads the resolution, it seems based essentially on 5 topics. First, the characteristics of artificial intelligence systems. Then, the equivalence that can be established between the operation of artificial intelligence systems and the control that the car owner exercises over or in relation to his vehicle. Third, the need of a convergence between the liability of the operator and the liability of the producer of artificial intelligence systems. I have to mention that this resolution is foreseen for the operator of the artificial intelligence system, since what is now taking place is also the discussion about the revision of the Product Liability Directive in order to accommodate artificial intelligence on the field. Then the requirement of proportionality. So the idea is to have a regime that balances liability models and the development of artificial intelligence for the benefit of the community, recognizing that artificial intelligence is in fact a tool that benefits community. And finally, what I would say is the fifth essential topic is the need of creating an insurance market for this liability related to artificial intelligence. Well, based on these topics, the proposal has differentiated between 2 different regimes. So this proposal, as it happens with the proposal for regulating AI in Europe, distinguishes between high-risk situations and low or moderate risk situations. For high-risk situations, what the European Parliament proposes is strict liability. And regarding the moderate or low-level risk situations, it proposes subjective liability with a presumption of fault. Well, now comes my critical perspective on this. Well, first of all, this proposal of using traditional models and of distinguishing high-risk situations from low or moderate risk situations is, I would say, in contrast with some of the assumptions in which is the resolution based. As I said, it is based basically on 5 essential topics. One of which was, as you remember, the characteristics of artificial intelligence systems. Well, if one considers that connectivity, dependency on external data, or vulnerability to cybersecurity breaches are common features of artificial intelligence systems, independently of being high risk or not high risk situations. So what I would say is that the European Parliament seems to propose to soften the risk-based liability, removing from from strict liability what by nature of things could be dealt with by strict liability, and which is the disruption of the control exercised by the operator. So this is really the cause for strict liability, and having in mind the characteristics of artificial intelligence systems, again, connectivity, dependency on external data, and vulnerability, there you have, for all artificial intelligence systems, reasons for adopting a strict liability regime. But then if we consider another exception, which is the parallel regimes, I think this idea is even more compelling. Think of the liability of car owners. Let me take the example of the Portuguese legal regime, but as a paradigm of other legal regimes. In accidents caused by land vehicles, there is no distinction whether the vehicle is being driven for commercial purposes or for personal activities, whether it is a new or used vehicle, whether it is large or small, whether it is being driven in an urban or rural environment. In all these cases, being high risk or low risk, since there is the risk of disruption of control over the vehicle, the legislator has adopted as a unique strict liability regime. Also, product liability. The same has happened with product liability. The European legislator didn't make any differentiation between the regimes applicable to products on the basis of their greater or lesser proximity to the public or greater or lesser probability of serious harm arising from them. What is the reason behind the product liability directive? Well, it is the impact of the technological revolution on production. That is the grounds for strict liability of the producer. There is no distinction between these criteria that, if we relate to artificial intelligence, would mean distinguishing between high risk, moderate, or low level risk. So I think if we take into consideration the parallel regimes, as I said, which are one of the assumptions of the resolution, then the conclusion should be different from the one that was drawn by the European Parliament. And also the principle of proportionality, because if one considers the principle of proportionality trying to safeguard the development of civil liability for the benefit of community, one cannot lose sight of the parallel regimes, as we have seen, and also, and most important of that, most important of all considerations, is that one cannot silence the European Union's commitment to increase citizens' confidence in the development of emerging digital technologies. This is one of the reasons for adopting a regime for civil liability for artificial intelligence. So the citizens' confidence requires something more than the European Parliament is delivering. And if one reads the regime, of course, I don't have time to go into detail, but one sees that, for instance, regarding the causes for excluding liability, the European Parliament, in fact, realizes it is a paradox what is proposing. And regarding the exclusion of liability, it considers that although there is a fault-based liability for moderate or low-level risk situations, the operator should be objectively liable for an action of a third party if it is impossible to locate that third party, or for the affected party to obtain compensation from him, and also, which is an element of objective apportionment, if the AI system has given rise to an autonomous activity, device, or process, it will not suffice to allege such autonomy to exclude responsibility. So you have some elements of objective liability within subjective liability, which may seem as a paradox, but as I say, I think it just translates this kind of disruption that the proposal creates on what should be a strict liability regime for dangerous activities. Well, but most of all, and let me take this last 3 minutes to highlight what I think should be thinking out of the box. And I think we are still thinking inside the box, not only in Europe, but I would say everywhere. There was a resolution of the European Parliament of 2017, which was much more ambitious. And there you have two basic ideas which I support. One was the establishment of compensation funds of broad scope. And the second one was perhaps avoiding the need to establish compensation funds of broad scope, the creation of a status of responsible electronic persons. What I think is that this resolution of 2020 reflects is the lack of ambition that is required for a paradigm shift in liability that is associated with the features of artificial intelligence systems. There is this very important document which I suggest everyone to read that was produced by the expert group on liability and new technologies that was appointed by the European Commission, and that relates to liability for artificial intelligence and other emerging digital technologies. There is just one line that reflects my idea, although the document itself, I think, has a very conservative approach. But this line says the following: this is the time in which we have moved from an anthropocentric and monocausal model of civil liability, which is the model of civil liability that was considered and regulated in the first civil codes, an anthropocentric and monocausal model of civil liability. We have moved into a model in which machines cause the damage, and also because of connectivity dependence on data, there is not a monocausal model, but a pluricausal model of civil liability. And if that is the case, then we have to think out of the box, as I said. And what I propose is probably it should be a good idea to think of an electronic person. Of course, we have to think of a model of funding this electronic person that would compensate harm in cases of more dangerous activities. We're thinking about high risk, so moving from civil liability to from civil liability within a traditional paradigm for civil liability based on an electronic person. But if that is not acceptable because it has generated a lot of negative reactions, then we should move from civil liability to a social security system or a private funds system in order to guarantee that plaintiffs are awarded damages. I think it's not feasible. I have heard with a lot of attention what Andrew has just said previously, but imagine what it will be like to be years and years litigating in court with difficulties with evidence, especially regarding autonomous artificial intelligence systems. I think we have to guarantee confidence to citizens in order to citizens accept artificial intelligence, and that demands something more than civil liability. Would that mean that civil liability would be excluded? Of course not, because civil liability has a preventive function, it has a regulatory function, but civil liability then should be, and I will conclude, should then be limited to cases either where we admit compensation by an electronic person, or if that is not the case, harm caused by activities that are not high risk, and the exercise of the right of recourse between the perpetrators of the harm. And this last idea, I think, is very much important for me. I think that civil liability should move from the relation between the tortfeasor and the plaintiff to the relation between tortfeasors or potential tortfeasors. So litigation should be mostly limited to potential tortfeasors by artificial intelligence systems. And in order to safeguard plaintiffs from litigation that I would say it would be hell. Well, thank you so much. And of course, I'm open to any questions that you might have. And sorry, Jose Miguel, for the 2 minutes that I took from the panel. Sorry.
They were worth it. Thank you so much. We move back to the room, but it was an excellent overview of what is going on in Europe. And I share with you the criticism of the European Parliament resolution. I never liked the European Parliament that much, so I'm not surprised that what they did was not great. So, Natalie, up to you.
Thank you. Okay, the title of my presentation today is the application of Australia's discrimination laws to algorithmic discrimination. It's based on a journal article that I've written. To set the mood, I've got a quote there from Professor Ajanwa from the University of North Carolina. She says that algorithmic decision-making is a civil rights issue of the 21st century. The central question that we'll be considering today is, can Australia's discrimination laws provide redress for algorithmic harm? To ground the discussion today in something really concrete, we're going to have a look at algorithmic hiring systems. And when I use that term, I mean computer systems that are powered by machine learning algorithms deployed at the screening stage of the recruitment process. So typically, to work out if you're going to get an interview with a person. So these systems might be fully automated in that they do make recruitment decisions. An example of that is when someone is screened out of a recruitment process without human involvement, or they might be partially automated in that they provide predictions or information to human decision makers to make the recruitment decisions. Some examples of these systems are CV passing systems. So these systems analyse CVs based on job-related keywords and other information to score and rank candidates. Another example are video assessment systems where a video of candidates answering interview questions are analysed. Systems score and rank candidates based on things like language, the audio features of their voice, and some systems also analyse based on facial and emotion analysis. Another example are text interview systems. These are becoming more common in Australia. These systems analyse the written responses of candidates to open-ended questions based on features that are extracted from those written responses. Spoiler alert, we know from the work of journalists, AI scholars, activists in the field reporting on examples such as the Amazon recruitment tool that systematically discriminated against women, that algorithmic hiring systems can perpetuate algorithmic harms, particularly of discrimination. I think it's important to reflect on those algorithmic harms for a moment because a lot is at stake when these systems are used. So these systems are able to perpetuate, entrench and amplify discrimination against historically disadvantaged individuals and groups. They're able to lock protected groups out of the workforce, thereby curtail their life opportunities. And they're able to do this at scale. For example, HireView, a vendor of video interview systems, reports that in 2021, they conducted 7.5 million interviews. So that's just one vendor in 1 year. So I thought that a good way to work out if Australia's discrimination laws can apply to algorithmic discrimination is to consider a couple of examples. We'll be looking at 3 today. So this is the first one. And it's an example of automated discrimination. So in this example, you're a woman of colour and you apply for a customer service role. The employer requires that you undergo a video interview. The algorithm in that system analyses those interviews and scores and ranks you on things like personality, communication skills, and whether you'll be a good fit for the role. The bottom third of applicants are automatically screened out of the system without any human involvement. Although the employer doesn't know this, this system is less accurate on the faces of women of colour and you are automatically screened out. You don't know this though, you just receive a rejection email 2 weeks later. So, do the direct discrimination provisions of Australian law provide you with a remedy? Assuming that you can, of course, prove the mechanism of discrimination by the system. I would say that the answer is it's unclear. The direct discrimination provisions of Australian law are designed to provide equal treatment. That's what they're concerned with. So applying the modern formulation of these provisions found in acts like the Victorian Equal Opportunity Act, you'd have to say that theoretically, yes, these provisions do apply because the job applicant has been treated unfavourably because of her race and her sex. She's been treated unfavourably because she's been screened out by this system. However, all laws and jurisprudence in Australia are framed with a human decision maker and a human decision-making process in mind. For example, all of our legislation talks about a person treating another person less favourably, whereas here it's not a person making the discriminatory decision, it's an algorithm. And unlike a corporation, there's no legislative provision that makes an algorithm a person for the purposes of discrimination legislation. To frame the Discriminatory Act as that of a person, however, I would argue, is an uncomfortable fit, particularly where the employer and its agents aren't aware that the job seeker, for example, has a protected attribute. We don't have time to go into it, but laws or elements of the offence like causation are really premised on the human decision maker. In addition, Australian law doesn't provide protection against intersectional discrimination. So here, you were discriminated on the basis of your race and your sex, 2 intersecting protected attributes. But in Australia, to date, the law can't recognise that form of harm. So I would argue in this area, some form of legislative reform is necessary. Okay, moving on to example 2. This one is to do with proxy discrimination. So proxy discrimination, I would say, is the most common form of discrimination by an algorithmic hiring system. These systems don't use protected attributes to assess applicants. They use features, a whole range of them, some of which might be so closely correlated with protected attributes that they're really seen as proxies for them. So let's have a look at this example. In this example, you're a woman who lives in an outer Melbourne suburb and you apply for a job as a software engineer. The employer uses a CV passing system to score and rank applicants. This system was trained on previously successful applications for the role, most of whom were men because of historical factors, and therefore the system downgrades applications that contain the keyword women's, gives extra weight to applications that contain the word cricket, and downgrades applicants that live in an outer Melbourne postcode. Again, you receive a rejection email 4 weeks later. Do the direct discrimination provisions protect against this form of discrimination? And again, I'd have to say maybe. It's unclear. Discrimination legislation in Australia deals with proxies by way of something called the characteristics extension. That's meant to pick up proxy discrimination and ensure that liability is not evaded by using characteristics that are integral to a person or stereotypes of people based on protected attributes. Whether or not something is going to fall within this extension really depends on how broadly or narrowly the court defines it. So in this example that we're looking at, on your CV, you said that you attended a women's college and also that you were a women's chess champion. So I'd argue that these are characteristics that attending a college or being a women's chess champion is something that does generally appertain to women. It's a characteristic of women and probably would be protected. However, not playing cricket and therefore not having that word on your CV, I would say that's probably not, it's too remote. It's probably not a characteristic of women, so would not be protected protected by those provisions. Further, living in the outer Melbourne postcodes, again, that's not a characteristic that appertains to women, it's not a stereotype. But I would say that it is a proxy for socioeconomic status. However, that's something that's not protected in our discrimination laws. It's not a protected attribute. So in some of those situations, you might need to rely on the indirect discrimination provisions, which we'll have a look at now. Okay, in this third example, you are a non-native English speaker and you apply for an entry-level role in a government department. You're required to undergo a screening text interview where you provide written responses to 5 questions. Again, an algorithm assesses these responses and scores and ranks applicants, and you receive a rejection email a couple of weeks later. You believe that this is because you don't have a native English background and that your written expression probably differs from that norm. So can the indirect discrimination provisions provide a remedy in this case? Again, the answer is theoretically yes. These provisions, the indirect discrimination provisions of discrimination laws, are designed to address structural and systematic discrimination and may require unequal treatment to redress historic injustices and achieve equal outcomes. These laws are concerned with treatment that on its face appears to be equal, but in fact has a disproportionate impact on protected groups. So in our example, it's likely that the employer would say, this system's fair. Everyone submitted to the same system, everyone answered the same questions. And the issue will be, did this system have the effect of disadvantaging people who have the protected attribute of race? I can see that there are a lot of difficulties in applying these provisions to actual practical examples. I can't really go into all the ins and outs of that here. Suffice it to say that I think there is a real need for some soft law, some guidance around this in Australia as to guidance around discrimination by hiring systems. You know, we don't, for example, have any statistical thresholds or guides in Australian law as to when disadvantage has occurred. That's unlike some comparable jurisdictions. And there are no agreed fairness metrics to assess disadvantage. There's no agreement even that we should be using fairness metrics maybe in this situation, because there is an argument that they're more concerned about equal treatment. A good example of the kind of soft law I'm talking about is provided by the Equal Employment Opportunity Commission in the US's recent guidance in relation to the Americans with Disabilities Act and the use of algorithmic hiring systems. So to conclude, I would say that these new forms of discrimination have exposed existing problems with federal and state discrimination laws in Australia. These laws are in need of reform and updating. Happily, the Australian Human Rights Commission has recently reviewed these laws and has a reform agenda, but that agenda didn't address algorithmic discrimination, and I say that there is a specific need to, there's a particular need to look at that form of discrimination and the applicability of those laws. I've highlighted a couple of specific reforms that I think are necessary today. I've spoken about the development of soft law guidelines. I also think that we maybe need to relook at the scope of our discrimination law, maybe to include social class or socioeconomic status. Until all of these things occur, I don't think it can be said with any certainty that Australia's discrimination laws can provide redress for algorithmic discrimination. Thank you.
Thank you very much, Natalie. It was definitely insightful to hear someone talk about experiencing with human rights in Australia and how to apply to AI. And finally, we go to John. So if you are sharing your slides, you can start sharing now.
Why is this not sharing? Desktop, yes.
I was going to risk it home.
Don't worry. I'm not sure what's happening. I'm not sure I can share that screen, but maybe my technical expertise is got ahead of me. But I can speak because I only had one slide, and I'll speak directly. Look, what we've heard to date has a lot of has said a lot of the things which I think certainly have come to my mind about these problems. As Henry started off, opacity of these systems is a major issue. That creates a forensic problem, and the inability to actually to identify what has gone wrong, what is causing the issue. So in the discrimination cases just discussed, how does the person who thinks they've been discriminated against get to understand whether or not they have been without a deep forensic inquiry as to the operation of the systems being used? If I could move to the area which I've been involved in, I should preface it by saying that motor accident injury schemes dealing with death and injury caused by motor vehicles on the roads in Australia operate at a federal level, at a state level in a federal system, and there are variations between each state. But there are some commonalities which are very important. One is the efforts to eliminate the costly court-based resolution of disputes, the movement, therefore, to administrative-type decision-making systems, either using administrative tribunals or determinations of issues by administrative people. And thirdly, the development of no-fault systems, though in Australia, there are only two schemes which I describe as fairly pure no-fault. Most of the schemes still permit some form of common law claim. So the matters I was asked to look at was really the problem of moving from a situation where the behaviour of drivers was the determination of fault. Oh, thank you very much. Whoever did that, that's magic. The behaviour of drivers who to determine fault, to the behaviour of the product. And one of the problems in relation to automated vehicles, and we're really only looking at those vehicles where there was no driver, that is the level 4, level 5 type vehicle under the Society of American Engineers standards. But it's not just the vehicle. There's a complex interaction of systems in the vehicle and outside of the vehicle. So the vehicle may be sending various forms of signals. It may be receiving signals from external sources. And that means the forensic problem of the identification of where the cause of something lies becomes even more difficult. Traditionally, for the determination of liability, you turn to negligence, as we've discussed, and also Australian consumer law. Henrik might be interested to know that we basically have adopted something pretty close to the European product liability laws, so that defective products which cause injury or death give rise to pretty much a no-fault right of action, subject to some limitations. But the problem with those provisions is that they don't really deal with the real world position in relation to motor vehicles. When you buy a motor vehicle, it's going to be serviced and updated over its lifetime. And let's say a vehicle will have a 10 or 15 years lifetime. You have, in words, a constant interface between the provider of the product and the operator of the vehicle. That interface is really not dealt with. Similarly, some of the defences available under product liability law seem inappropriate, such as a state-of-the-art defence. So it seemed to us that neither of those provisions were going to be, neither of those approaches, that is traditional negligence nor consumer law, was going to be very helpful in a system where the key desire is to make sure that the costs of resolving disputes are kept to a minimum, and that most of the money which is utilised under the compulsory insurance arrangements and paid as premium by the operators of vehicles is applied to actually delivering compensation for injuries and death, and doesn't go to third parties such as lawyers and the like involved in the process of dispute resolution. So the complexity and cost was a driving issue in relation to looking at these matters in order to come to some form of approach which could be adopted. The recommendation was that the best solution was to impose the liability statutorily on the manufacturer of the vehicle, or where the manufacturer was not present in Australia, on the importer or even distributor. But to leave that person, that is the manufacturer, to take that example, with unfettered rights to seek compensation itself from other parties who may be involved in its liability. So if, for example, the provider of some part of the system which had the result of manoeuvring the vehicle was potentially liable, the manufacturer was unhindered in being able to seek compensation from that party. The second element was to ensure that, as Henrik has pointed to, the need for assets to be available to meet the liability. Now, that could be done by several methods, but one of them obviously is some form of insurance. Or it could be by other means, whereby a fund would be established, which the manufacturers would have to contribute to. And that's one of the problems with this idea of creating legal personhood for algorithmic systems or the like. That will create a limitation on liability, because there will be no asset which will be available to meet claims that may be made, unless there's also a requirement that that new legal person has to hold assets or hold some form of insurance which is available directly to third parties who are affected. Now, if I just return to the idea of negligence, how do we determine fault in this circumstance where we're saying there's a strict liability on the manufacturer for an outcome? I think the truth is it's got to be a set of rules focused on outcomes rather than the behaviour which leads up to that outcome. But it can't stop there, because let me take the simplest example. a automated car is parked and there's a collision between that vehicle and another passing vehicle which causes injury or death to someone. In those circumstances, you can't apportion the liability to the parked vehicle if it was legally parked, for example. And there are a whole lot of other areas where this apportionment issue might arise. So we might need to look at how do you apportion the loss, that is the compensation payable to the injured parties or the deceased estate, between the automated vehicle and other vehicles in a motor accident. Oddly enough, this is an issue in Australia which has been addressed because insurers have formulated systems as between themselves for the apportionment of claims in multi-vehicle accidents. Again, with the view of simplifying the dispute resolution process and identifying who's liable. We have another model of that in Australia in relation to asbestos claims, where, for example, a victim may have worked in multiple locations and been exposed to asbestos in different places. That is dealt with by a legislative framework which establishes a process to determine the contribution to be paid by each party. Now, the problem with this is it doesn't necessarily have a universal application. It may be that you have to create different approaches where AI is being used in different areas. If we've just been speaking about AI causing discrimination, which is essentially financial loss, the problem there is that the fundamental idea of discrimination is, has there been discrimination as defined by the law? Now, without the forensic inquiry, it's very hard to know whether that is the case. Now, I haven't thought through that at this stage, but it seems to me that's the sort of issue one has to address. How do you frame the law in a way which provides a remedy, and we're talking largely about remedies to consumers or the general populace, in a way which is not going to be overly expensive and complex and involve long delays because of the difficulties of the forensic inquiry, nor subject to the barriers which will be thrown up by many that you can't have access to our algorithm because that's confidential, etc., and other types of barriers of that sort, which you can see occurring. So to step back, in the context of motor accident injury schemes, the suggestion has been that the scheme should be entitled to recoup its loss from the manufacturer where the vehicle's behaviour, that is the automated vehicle's behaviour, is such that you would allocate or apportion to that part of the loss arising from the injury or death. So if the vehicle, like in Henry's photograph, behaves absolutely aberrantly and runs into somebody or goes through a red light or whatever it might be, or is speeding or whatever, or does something which is totally unexpected and indicating a breaking of the road rules, then you would allocate to that vehicle and that manufacturer a liability approaching 100%. So that's my contribution to the debate. But I think at the end of the day, we need to start thinking more fundamentally about the laws of negligence and how they really should work, where we're dealing with this problem of the opaque AI system creating loss in different circumstances. So thank you very much. And sorry about the slide, my inability to share it.
Thank you.
Thank you.
So if we can ping both Enrique and John on the screen, we'll open the Q&A. I know I have plenty of questions, but I think the priority is to address yours. So who wants to start? Okay.
Thanks for a really interesting and informative presentation. Now, I should say that I have a question for everybody. I don't know if you want me to ask everybody a question or just ask one question.
We have 14 minutes, so.
Okay. Well, I'll just ask each person a question and then they can decide whether they want to talk about it. My question, I have to remember everybody's name. So, Henry, I do know your name. So, thank you. Actually, I should say all the presentations were really interesting, so thank you so much for that. Henry, my question for you actually was, it's really interesting to talk about negligence, so I agree with that, because I think the law, whether even if you're looking at product liability, it comes back to questions about fault anyway. It just comes from a different way. So I think that's a really useful approach. And I also really liked that you looked at the Travago case, which I think is such a good case about how the ACCC framed itself beautifully. My question for you, which you might not want to answer at this point because you may not have thought about it, is just if you go to that Vioxx case, which is a case on product liability, and I think it's the point that John raised, the court accepted that the product in question did cause harm in a certain percentage of people. So it got over that first causal question. But then on the second causal question, it said that you, the plaintiff, can't prove that you were in that 50%. So there's a chance of quite a high chance of harm, but the plaintiff couldn't prove they were in that category. And I just wondered if that's the hurdle to the statistical methods, or whether we need to go, the risk of harm is enough in this context.
Yeah, that's a really interesting question, and as you said, I haven't thought too much about the Vioxx case. I mean, I think one thing I should caveat is that given what the other speaker said, it's definitely something I want to make clear. So I'm not suggesting that we should apply a pure negligence fault-based approach, but negligence is helpful because it helps you think about the types of inquiries that you might make about fault and causation. And even in product liability, as you say, there are questions about whether you've met a level of safety that the public's reasonably entitled to expect, which can again be presented in a statistical way. So, yeah, my sense is that these evidentiary burdens are going to be really hard to overcome, but in some class, all it takes is one impactful case to make a change in practice. Especially at this stage, it's not as though the practice is impeccable and we've got these brilliant end-to-end risk management in the automated systems that are there. So or that the problems that are coming up are hugely hard to see as being unpredictable or complex, right? It's if automated vehicles, a large number of object detection systems can't detect a cycle coming down the road directly at the car on the wrong side of the road, we're not dealing with a really difficult question. So in some cases we are, but in some cases we aren't. And while we wait endlessly for regulation, I would like to see the existing laws used better. Yeah, I don't know if that answers the question or sort of diverts it a bit. Yeah.
If anyone has to move, otherwise we'll go back to work.
Hi everyone, thank you for an excellent panel. That was super interesting. I suppose, very interested in perhaps the aversion to having companies or users of algorithms make those available for scrutiny by the courts. In some ways, I think courts and are sort of the perfect forum for maintaining confidentiality and sort of preserving whatever's being described as commercial in confidence. And like, this is quite a tangent, but I've come from a background of working in native title and sacred site protection, where Indigenous claimants are asked to disclose sort of their most sacred beliefs in the context of the court for the purpose of proving their connection to land. And I'm not as familiar in a commercial setting, but I'm sure there are contexts where commercial and confidence information is kept secure in the court. So yeah, I'm just wondering if you think there is scope to kind of put an onus perhaps on companies to provide more explicability in what they've done.
Yeah, is that one in for me? For everyone, I'll let someone else answer.
I'll just make one comment on that. One, you're right in saying courts are good at that stuff, but one possibility is to think about reversing the onus of proof. That is, if there is a basic injury done or a loss incurred or an apparent wrong, then you reverse the onus of proof. That will be most strongly opposed by the business community, though, because I suspect they'll see that as, in effect, imposing a strict liability on them in circumstances which doesn't align with what might be described as our rights-based systems of law. But that's one method of doing it. And then they can choose as to whether they expose their material to the court and to inquiry in those circumstances. But it's a tough approach, but it's one that might work.
Can I slightly modify the question for you? I don't know but if imagine that you are the person who has been discriminated and she doesn't know it. So can you come to the court and say, I think I may have been discriminated? Is that a reasonable approach to then, like, because of this and that, which you have to tell the court that that's
Well, that's a great question. You need to, if you want to lodge a complaint, you need to be able to basically set out some of the basic elements of that complaint. Mm-hmm. And so this is one of the difficulties, because you get stuck in this loop. Mm-hmm. And I definitely think that there does need to be regulation that provides for people to be notified when they're subject to automated decision making, and that some form of explanation is provided. And also really support John's call for a reversing of the onus of proof once a prima facie case of discrimination has been made out. And that's in discrimination law. That's an idea that's been around for a long time, and one that is gaining traction.
Could I make a further comment on that quickly? In the Hayne Royal Commission, the banks resisted strongly remediating wrongs they'd done to people who had not realised they'd been wronged. But the regulator, and in that case the Royal Commission, forced the banks and other financial firms to actually make payments to people who had no idea that they'd been wronged. So there is a role for a powerful regulator to actually force organisations to compensate people who are not aware that they have in fact been wronged, or in this case discriminated against. Mm. But the regulator's got to have funds to do it, and it's got to have power.
It's interesting because, in my view, if you get a regulator with that kind of power, where do they decide to start if they don't know that discrimination has happened? So, for example, they would need to start sampling different systems and just saying, well, does this work? But just allow like some kind of targeting. Anyway.
Well, they could have a program of auditing. Is one example, yeah. Or one person might make a complaint that they believe a system has discriminated against them, they don't know for sure, then that regulator can of its own motion investigate that at a more systemic level on behalf of everyone who might have suffered the same discrimination. So again, John, I support your call for regulation, a public regulator.
Well funded.
Well funded, absolutely.
Sorry, we have a question here.
My question is actually for John and Enrique, and I do want to say thank you for a great panel. It was really good. My question is in relation to the idea of strict liability for autonomous vehicle accidents or similar situations involving autonomous decision making, I guess. I was reminded of some of the debates that were happening around like the early days of the internet, right? When people when the decision, particularly in the US, was to provide a kind of safe harbor to businesses engaged on the internet, which we would now call intermediaries or platforms, to do things online and experiment in order to sort of see what happened, because their argument was if we're going to be under the threat of constant liability, we're not really going to be able to do anything. And that's not necessarily an argument I agree with, or, you know, we could say it didn't really get us in a great position with all these big media, Facebook and whatever. But I was thinking, I guess, about new market entrants for technologies like autonomous vehicles, and that there might be that sort of argument that a strict liability approach would make it harder to get insurance, or harder for smaller entrants or people to try to innovate in these spaces if you're not Elon Musk or something. And I was wondering what your thoughts were on that.
Enrique, you start.
Well, again, coming back to what I said, I think this is a time to think strategically. This is not the time to address particular or specific topics, and that question is very interesting because it addresses the beginning of everything, and this is the beginning of a new era. As I was saying, from now on we will have machines making decisions. We're talking particularly of autonomous artificial intelligence systems. And these machines probably will not be as auditable as a human action. And again, these machines will probably be just one of the causes of the damage. And so if we are thinking strategically, I think we have to create a safe harbor for plaintiffs. And without compromising the benefits of civil liability. And that's why I say I think these questions that we are addressing, like the reverse of the onus of proof, and this kind of solutions of presumptions or of causation of faults, these are solutions that should be considered just for the exercise of the right of recourse in order to, again, safeguard the interests of citizens. And also, strategically speaking, in the interest of artificial intelligence, again, as it has been said everywhere, and don't forget that when we talk about regulating AI, it all started with an ethical approach. Now we are dealing with a legal approach. But everywhere and anytime it has been mentioned that one of the main aspects of regulation is to create confidence in citizens regarding artificial intelligence systems. I mean, people have to be confident when using artificial intelligence systems, and that if that is the case, then we have to create the possibility of getting compensation without having the ordeal of going to trial, and even with the benefit of having presumptions of litigating against huge corporations for years and years and years, precisely because they have the means, the plaintiff doesn't. So what I wanted to say, and I'm sorry for taking so much time, is that if we're talking about this, it's because this is the time to define the boundaries in terms of strategy for regulating artificial intelligence, in this specific case, through civil liability. And I think what is most important is to guarantee that without compromising that regulation role, we need to give the plaintiff the absolute certainty that they will be compensating in case any injury occurs. I'm sorry, John.
Yeah, I agree with that. On that question, I'm going to say, if you read the American literature, there are a lot of writers in the US who are saying the world will fall in, the sky will fall in, nothing will happen if you don't give us a safe harbor and allow us to get on it and do it as we like. And there's still safe harbors protecting the internet providers like Facebook in the US. But it seems to me that if you're going to develop AI and use it in the public arena, that is particularly in the consumer arena, at the very least, you should have those systems properly tested and have some process of assurance that they are suitable for purpose. And that may give rise to either regulatory rules, for example, for cars to operate on the roads in Australia and elsewhere, you've got to meet design rules, which are regulated. Now, unfortunately, there's a lot of self-certification in that, so there are some problems. The other side is to provide due diligence type defences, which are not broad like that, but which require that systems are not put into operation where they are being utilised in the public space without appropriate testing and what have you, and auditing, or however you like to call it. I mean, so there's a major problem for just auditors at the moment as to how they audit AI systems, particularly when they're being used in management in big organisations. So this issue is very large at heart. We're talking about some particular cases of the issue, the utilisation, the discrimination, hiring problems, the car problems, and things like that. But in truth, as we move forward, these systems are going to be used in a much wider context, and we're going to have to think through very carefully how the law responds to that and where liability is imposed and in what circumstances. I think that strict liability is one approach, but it can't be absolutely strict. There has to be an ability for some process of apportionment. My example of the parked car. I think the legal profession needs to think about the jurisprudence of negligence in a very deep fashion and start thinking about how it may develop. I'm not sure that the courts are going to get there, and it may require some statutory assistance.
And I think with that thought, we can wrap it up. And let me thank all the panelists, and especially thank Henry, who put this panel together by himself. Thank you very much.